So good afternoon. Today we have Andrew Riley, a colleague of mine, and he teaches law at American University, in particular intellectual property practice before the ITC. But today we're here to talk about a hot topic in patent law, and that is what can you patent in the first place, and in particular what's eligible. And I know this is a major concern for anyone in the software, not just the software industry, but especially in the software industry. Before they invest in a patent, they have to ask themselves, is it even worth, can we patent this? And that's the simple question. But Andrew, if you could tell us at least what guidance we have right now to help make that decision as to whether we can patent things like software.
Thanks, Jeff. Yeah, this is pretty clear. You would think at first when you read section 101, which is about the subject matter that is eligible to be patented. And I won't read the statute, but essentially boils down to four things: process, machine, manufacture, or a composition of matter. And then over the course of years, really decades, the courts have provided some exceptions to that. And those exceptions are, you cannot patent a law of nature. So gravity, you can't patent gravity. You can't patent an abstract idea, and you can't patent natural phenomenon. So we have sort of four pretty clear categories and then three exceptions. Unfortunately, it still leaves us with a lot of people still scratching their heads about whether or not their ideas are patentable, which has led us to this case that is in the news right now.
Yeah, and this case is the reason we're having this conversation right now. It could have a tremendous impact on those industries, patent litigation, and hopefully some help in answering that question. But we're going to get into also the potential it could have on who makes that decision. And there's two issues right now before the Supreme Court. And one is, what is the standard? And we'll talk a little bit more about what they're wrestling with there. But the other one is this decision a question for a judge, or is it a question for a jury? In other words, is it law or fact? And Andrew, if you could tell us how most courts, almost all courts, are deciding this issue right now.
Yeah, right now, some of the courts are allowing jurors to answer sort of an underlying question about an alleged invention. You know, are some of the recited activities in the claim itself, a lot of these claims have to do with method claims, you know, are those activities well understood? Are they conventional, or were they routine at the time the patent application was filed? And so those are some of the questions that are being posed to jurors as sort of a predicate before the ultimate decision under Section 101 is asked. You know, is this something that could be patentable under the patent statute? So that's sort of the where we are right now, is that it's a mix of some fact questions are given to a jury, and then the ultimate legal conclusion on Section 101 is still with the court. So you have this sort of mixed area at the moment, but there's some folks who believe that it should just be entirely a question of law for the judge to decide. And then there are others who are saying, no, there's more than just these, you know, sort of somewhat simple questions that you might ask a jury about being conventional or well understood or routine. There's other things, you know, if it involves sort of the application of a natural phenomenon, is it being applied in a way that is novel or new, and would that be inventive? And so that's what the system right now is sort of wrestling with, these two issues, and that's what this case is going to hopefully get some resolution on.
Yeah, let's take a look at that case. I'll share my screen, Andrew, and if you can see this. Can you see that?
I can now, yeah.
Okay, so this is the decision, the Federal Circuit decision, and American Axle was the patent owner. They had invented, this is their brief, sorry, this is not the decision, this is the petition to the Supreme Court by American Axle, but they claim to have invented a new process for making a quieter automobile drive shaft. I find that interesting because this is not a software patent. This is not perhaps your typical 101 question. mean, their invention is a quieter automobile drive shaft, or at least a process of making it. So their concern is that this decision will prevent this type of invention. And what happened is the federal circuit said that because in the claims in the patent, this process was basically using a natural law, Hooke's law, to make this quieter automobile drive shaft. And so that was the basis of the federal circuit decision. So if you're using this natural law to make your invention, then you can't patent it. All right, here are the two questions presented. One is the standard. What is the standard is what they're asking. What is the standard for determining whether a patent claim is directed to a patent ineligible concept? And here's the big one here. Is it a question of law or a question of fact? And this is the decision. In fact, the end of the decision, this is the dissent from the federal circuit in this case. And you can see that Judge Moore here said, we should not be deciding technical questions, all right? And in this case, whether two types of vibration are reduced by application of Hooke's law. But I read this saying we shouldn't, as judges, shouldn't be making these technical questions, making these factual determinations. And that will likely be one of the issues before the Supreme Court. If we move up and see more about what Judge Moore said, you read here in the middle, it says, she's basically telling us we muddied these waters. Our inability to do so in the 101 space, in other words, our inability to provide clarity has been a mess of our own making. So this is the judge saying we have made a mess. The unfairness, confusion, uncertainty that will be caused by this opinion is on us. So this is the judge who dissented in this case saying we need more clarity. And if we look also at another brief before the Supreme Court, this is from a group, U.S. Startups Inventors for Jobs. This organization, their point here is they're saying that they believe patents are not as valuable as they used to be. And their words are strong words. The patent system is on life support, and that there simply aren't the incentives that there used to be. And their frustration is with answering that basic question, which is, can I patent this? And especially for software companies. And so they want clarity. Now, one of the, I don't want to call it a problem, but one of the results of the Supreme Court case is that potential results is that they could decide it's a question of fact, or that there are questions of fact. And to me, that doesn't necessarily provide certainty, because we know that juries are hard to predict, but it would have a tremendous impact on I think, the value of patents and how that case proceeds. And Andrew, if you don't mind, tell us what your take is on if the Supreme Court says this is an issue of fact, what does that mean for litigation over this issue?
Well, before, when Section 101 was a clear issue of law that was decided by the judge, patent litigation involved a lot of motions for summary judgment to the judge on just Section 101. And in a fair number of circumstances, the judges were granting those motions, and basically that eliminated the ability of the patent owner to continue to try to pursue infringement. The patent at that point was found invalid and they had to appeal. And that happens relatively early in a patent litigation proceeding when you file a motion for summary like that. With the change where some questions of fact were involved, that has slowed down the judge's decisions on summary, because there are these underlying factual questions that they want to give to a jury. And that gives the patent litigation more time, more legs, so to speak, to develop facts and for the parties to continue to litigate and ultimately get in front of the jury. So from a patent owner's perspective, that's a win, right? You want to get in front of the jury, you want to be able to argue your case that way. Whereas if you're on the defendant side, the accused infringer, it's sort of hurt one of your tools that you might have used early on in a case to make it decisive and to get a decision point that would make the cost go down potentially by having an early decision on summary. So it's changed that dynamic quite a bit by mixing in these questions of fact that are usually resolved for the jury. And ultimately, I think that that's going to give more power back to the patent owners. It's giving more power uh, to patents in general, right? They're going to be perceived stronger, and that's going to potentially affect their value in the marketplace as well. And from a trial lawyer's perspective, it's further complicating what already is a pretty complicated trial, where you might be arguing about other aspects of invalidity. You're going to argue probably that there are prior art references that disclose or anticipate the claims that are issue. You're going to have to argue non-infringement. And now if you're adding on top of that, you're going to be arguing about whether there's eligible subject matter involved. So it's going to further complicate what already is a pretty complicated proceeding, and making it much more difficult to be a trial lawyer in a patent case when you've got to try to simplify and, get those complex ideas across in a way that your average juror is going to understand.
Yeah, thank you for that, Andrew. And it's already having an impact on litigation right now. There was a case, I believe it was the Western District of Washington State, who decided not to decide this issue. So we're going to wait and see if the Supreme Court will look at it first. So it's already having an impact. I know some courts, district courts, have thrown these issues to a jury already to let them make some determinations. So I mean, it has an impact right now for patent litigators. I think down the road, from a business perspective, from an inventor's perspective, it could have a tremendous effect on the value of those patents and the decision on whether to get a patent, say on the software or business idea or any of these things that were harder to get a patent on in the past. So a lot going on, and we didn't get into great detail in these cases. I'll make sure they're posted on our website so that if viewers are interested, they can read it there. Thank you again for your time. It's always a pleasure. Look forward to doing this again.
Sounds good, Jeff. Thanks.